Ladies and gents, welcome back. We are finally we're finally seeing some action happening in Ottawa when it comes to a real courtroom and the Emergencies Act that the federal government invoked last year to quash the Freedom Convoy protest. And today, to join me, I brought Eva Chipiuk, lawyer extraordinaire, and most notably known online as the one to cross-examine Justin Trudeau in the inquiry into the use of the Emergencies Act. Now, the inquiry notoriously had no bite and a very disappointing end to it. And why is this different? What is different with what's going on here?
Right. So this is, like you said, in court. So it's in the federal court in Canada, and it's a judicial review. So what that means is it's not like a typical lawsuit that you hear when two parties are arguing against each other and there's damages for, loss of work or injury. A judicial review is when you go to court specifically to ask the judge to review a law made by the government. And you only have 30 days to go to court and challenge that law. So this is a court application that was made in March of last year, because, like I said, you only have 30 days in order to file with the court. And so it would have had to been filed before the revocation. And it's asking the judge, a court, to determine whether or not the actions of the government were lawful.
So does this have teeth? We know what would happen even if Justice Rouleau would have sided with the Canadian public and maybe a little bit of common sense. Had he sided that way, there would have been no recourse for the government. What happens if the government loses in this battle?
Yeah, so excellent question. And we always knew that these two cases were running in parallel, and we knew that, the government knew that. So unfortunately, it seems like some of the public didn't understand that. And on the first day of the inquiry, Justice Rouleau said that this is just a truth-seeking process. So yeah, there were people calling out that Trudeau should resign. And what we were always encouraging people to do is tune in, listen to what is being said, and then make a decision for yourself. And then, as you said, we were all quite disappointed with Justice Rouleau's report in the end, 2,000 pages of who knows what. I still have yet to read it because it seemed to flip-flop on its own face. But this definitely has teeth. So in the sense that any court decision becomes binding in Canada. So this is going to be binding in federal court on Canada. The thing is that, again, if we want to see that Justin Trudeau loses his job, that's not the power of the court. And this is actually an interesting point that Justice Mosley made. That's the judge presiding over this case, because we infamously know about the MOU that the government has been showing and talking about, saying here's evidence of the Freedom Convoy looking to overthrow the government. They brought that up, and Justice Mosley said, we're not talking about that here. That if that is anything, that is proof that we're not educating our citizens about the Constitution and their rights. Oh, wow. That was one amazing thing to hear. So
well, instead sad, though. I mean, that really is a sad fact that we don't know the laws, and we're a bit confused. And this is what I'm trying to do here. I don't know how it works, so I invite a lawyer in to let us know how does this actually work,
And it's a legitimate question. And really, Canadians shouldn't have to understand all of the nuances about the law, but we need to get Canadians more educated about basic legal concepts and how politics works. Because just because you have 30,000 or 100,000 or even 1 million signatures on a piece of paper doesn't mean that you have the right to demand that that they listen to you. That's just not how it works. Of course, that brings some attention to your cause, and then maybe politicians will get interested in your cause, but that's just part of a conversation. And it's been incredibly frustrating for the government of Canada continuously to wave around some piece of paper that we all know has no teeth and no legs. And at least one thing we heard Justice Mosley say is, put that away. That's just miseducation.
So the justification that Rouleau gave was that the Canadian government was inept. Essentially, they weren't able to do their job at all levels, and that's what made him feel as if this was the type of legislation that should have been used in this case. Now, the actual act itself, the Emergencies Act, and this was the big argument for everyone against it at the time, was, well, in the act it has a very specific set of criteria that needs to be met in order to invoke the act. Now, is that like a major arguing point in this case?
Yes. And that's where I'm really hoping the conversation goes. And there were a lot of very interesting and great arguments being made in court yesterday and today there's 4 different applicants and 4 different lawyers, actually more than 4 different lawyers representing 4 different applicants. So that's one thing that seemed to kind of be tossed around at the public order emergencies inquiry, that the government just had to change the definition because the legislation wasn't modern enough to encompass what a national security threat is in this day and age. But guess what? The only person that can change that legislation is the government. You can't just willy-nilly change it when you see fit, however you see fit. And that's something at a minimum I really hope a court will make a decision on and clearly show that the government went too far there. They needed to abide by this specific criteria when invoking the Emergencies Act. And there's very set guidelines of when you can do that. And they didn't provide the evidence that they had that. So I'm really hoping that's what the federal court judge is going to say.
This piece of legislation wasn't written in the 1850s. I mean, this is something this came about after, what was it, the October crisis and the War Measures Act and how that was abused. And I believe that the main purpose of the Emergencies Act was to tighten up the eligibility of the government to use it in the first place. So yeah, that's
yes. And quickly, one thing is the NDP party at the time was the one that was really dissenting on it, because it said the government can't just have this kind of power without a checks and balance. And it was the NDP party that pushed so hard to get this inquiry part in it. And that's what we saw. And so I just want to make that note, because we see how the NDP is acting now, just like hand in hand with the ruling party, when they were saying this is very big step of government and we can't just let them have a free reign.
So when I was reading about what was being said in this court case, I was starting to hear words like unreasonable search and seizure and infringement on individuals' rights. This is where this is where the focus was meant to be in the first place. The inquiry, again, wholly disappointing, but it looks like people are actually, like, we're actually looking into the legitimate reasons for this.
Yeah, and all of the civil liberties and rights that were suspended, that were just trampled on at the whim of the federal government without due process. And that's a huge thing that's been coming up. Like, when you just freeze people's bank accounts and you don't allow them to be able to purchase food and shelter, that's how much power the government took away. And Bathsheba Vanderberg actually was bringing it back to basic human rights. That's what the government took away with due process. They didn't have their day in court before all this happened to them. Literally, the government suspended people's basic human rights. And, I feel a little bit like there's been so much, and these very basic concepts and rights and freedoms have been disregarded, and we forgot to talk about those for a year.
And narrow in scope is always the words that we keep hearing from the government, but it seemed like more of a sledgehammer than a precision strike. A lot of guilt by association was being used in the implementation of the Emergencies Act when it actually was invoked.
Yeah, and I didn't hear too much narrow in scope from politicians, but that's certainly the way that the federal lawyers are trying to argue it. But I don't see what was narrow in scope at all. Like, with especially bank seizures and freezers, it was kind of a carte blanche to the banks. all that was narrow in their view, and that's what they've been saying from the beginning, the politicians, was the time. But that it doesn't mean that you could take advantage and quash all these rights. But we just did it for a short time. That's not, I don't think that's how the law works. So again, that's what I'm really hoping, that this judge is going to, at least at a minimum, talk about the rule of law and these basic rights that we're all expected to have in Canada, of all countries.
Well, we're hoping a lot that this new judge is a lot more fair. I heard in the rumor mill that he used to be a trucker.
That's right. Yeah, he let that slip today, and a trucker in Alberta was his profession before he became a lawyer, and he said he quit that because it was too much work.
Yeah,
So,
it is a lot of work. It's a ton of work. Well, Eva, thank you so much. Where can people find you and follow more of this?
yeah, I've been posting quite a bit on Twitter, so that's probably the best place to get me. Also on a TikTok, once in a while I'll throw a video up.
Oh, well, before that's banned, right?
Yeah,
All right. Well, we'll have you on again. Thank you so much.
my pleasure. Thanks for having me.